sure that there's a meeting of the mind, that there's an agreement between the parties, so those terms need to be negotiated. Certainly, you may go to an attorney, and the attorney might have you change something.
Right.
So you can still negotiate it as long as it's not signed at that point. Once it becomes signed,
Yeah.
if you're going to negotiate a change, then you need to amend the contract, and it has to be signed by all parties and agreed by all parties.
I suppose it depends on how valuable you are going to be to that company, so that'll come to where the leverage is in negotiating. If they really want you, then you'll have more leverage to negotiate some of those terms. Certainly, you lose some of that leverage after you go work there.
If someone is in this interviewing process, are they at a disadvantage if they say, sure, I'm coming in for that second interview, maybe it's even the third, but I need to bring my lawyer because we need to discuss what this is going to be? Is that, how off-putting is that?
I don't think you're going to get, now...
It's after they make the offer, right?
Yes,
Yeah,
right.
yeah.
And if they're the ones who are insisting upon having a written contract, then there's going to be an expectation, I think, if it's at a high level, that you're going to have a
Sure.
lawyer look at things for you.
Matter of fact, we put that in employment contracts.
Sure.
We put a language in it that said the parties have had an opportunity to discuss this with the counsel of their
Right.
choice.
Right, I think that's
So they had
expected.
legal representation.
At what, you mentioned management level, is that really the level at which you, only the level at which you need to have an employment contract?
I guess it just depends on, maybe not just management level, what happens if somebody comes in and they want to form a partnership?
Yeah,
And
and now we get into partnership
Yeah,
agreements,
yeah.
that's for sure. And if you're some kind of key employee, and that can be a salesman in
Yeah.
some instances who produces an awful lot of income for the company. It could be somebody who's got some really unique computer skills, perhaps, for a company that relies on that. So the management part plays a role in how maybe overreaching you might get because of your key employment situation with the company, but it doesn't necessarily have to be management.
And let's continue with that because that is another issue, the intellectual property. Someone isn't maybe upper level management, but certainly what they deal with is either highly technical,
Yeah.
highly sensitive, highly proprietary, and when they are employed or first employed, maybe they wouldn't have known the extent of their involvement and how privy they would be and how sensitive the information would be. When they have been employed and now are in that situation where they're very involved in the company and they leave, how does an employer protect himself so that that information or that knowledge or that client list or the program doesn't go with him? How do they protect themselves after they've already been hired?
I think a good example of that is working for Coca-Cola.
Sure.
Because that's such a guarded recipe.
Secret.
Yeah.
We'll have to kill you
Yeah.
if we tell you the
Because
secret.
anybody that works there
Right,
is
it's locked up and you
yeah,
can't get
and
it.
can't get the information. Computer companies with intellectual property.
Companies that have a process that they use, like Coca-Cola, to
Yeah.
make a product. Mallorca pearls jump to my mind in Spain.
that's
They,
right.
they make these pearls out of fish scales. Anything like that that's either patented or copyright, trademark, is protected by that law anyway, even without an employment contract.
But I think her question was, what happens if they, for instance, take your customer list? How do they protect against that? Assuming that there's an employment contract, the protection would be in the contract,
Right.
because if they find out that that has happened, then you could run the risk of being sued.
And at common law, there is some duty owed from an employee to an employer. And I think stealing, that could be considered stealing if you take
And it's proprietary information.
any proprietary
Yeah, yeah.
information, customer list or anything like that, you can get sued and an injunction can be issued to stop you from using that.
That's actually where I want to go with it, because a few employers said, well, this employee hadn't been significant enough or deemed to be significant enough in advance, or when he was first hired, to be thought of a potential threat. Yet, when the person had access to information, developed information, then left with that information, what's the employer's position? How does he stay protected? And what you
Yeah.
bring up is it being stealing.
That's right.
Certainly
Any,
brings that into
any property of the employer, and you can have intellectual property that you have a right in, even if it's not a copyrighted, trademarked, or otherwise protected piece of intellectual property. If it's something you've developed and you use, and an employee takes it and tries to use it elsewhere, you can sue to stop them from doing that.
Okay, and if you are a mid-level employee or about to be, do you need to have a contract that tells you specifically under what terms you could be fired or otherwise separated from your job?
I think to answer that question simply would be people go into a job knowing that there's an expectation of that they're not going to steal things from the company. But if you go back to maybe having an employment policy or an employment handbook, that would cover what
Sure.
what those
Terms.
what those terms would be. So.
And what about without an employment contract, do you lose your ability to sue if you think you were wrongfully terminated? Does anyone ever really
Absolutely
lose
not.
that?
No.
No, absolutely not.
She knowing the answer to that?
Right.
Yeah.
Well, and the answer, of course, is you'd have to be able to prove that there was some discrimination or some other protected area that you're suing for, because in Rhode Island, we still are employment at will state. So if they just fire you because they fired you, and there's no discrimination or other protected right that you could sue for, then you might be out of luck.
Okay, and relative to employment, if you are a freelance designer and you've come up with a swell idea and you are approaching a company and you think it's a good idea, but you wouldn't be necessarily the manufacturer of it, you would go to that company, be hired by that company, and then put some of your ideas into implementation and production. They often will want, the employer will often want confidentiality agreements. So let's discuss those a little bit.
Yeah.
It's supposed to protect that company, but on the other side, it also needs to protect the employee or the person who actually came up with the concept. How does the employee, who is certainly the little guy relative to an empire, such as a large manufacturer, how does he protect himself when he approaches the potential employer with his idea, that it stays safe for him? And then we'll talk about the
I've
employer
actually
side.
done this for clients, where I drafted a confidentiality agreement for them to present to
Right.
whomever they're trying to, offer the service.
Give us the checklist. What are some of the things that it included, without disclosing who it was, obviously?
This actually was, it hadn't been patented yet, but it was a little invention for a product, and I really can't say what it was.
course.
But we put in the confidentiality agreement, it described exactly what it was, that any information that would be taken from that or used from that would be considered a breach of confidentiality agreement. Same thing as a contract. These are the terms.
Yes, you lay out all the terms
Yeah.
that are important for that particular issue. And
Yeah.
as Jackie's saying, this is my idea. If you want to buy it, we'll talk about the terms of that, but if you don't, you can't use it for any other purpose.
And if you do use it for any other purpose, and again, it's just going back to, really, it's a
Right.
default clause. What's going to happen?
Right.
If there is a breach?
What happens if you breach?
Apparently, there is good reason for you to be very specific with those kinds of stories, because anecdotally, after helping people who wanted to enter the commercialization process, we've seen that the company that the designer would pitch would say, no, thank you very much, we don't really like that, but inside of a month and a half later, with a very minor change, ended up not only designing it, producing it, manufacturing it, getting it out into the market, and actually putting an advertising
Right.
campaign before the person would even have a chance to contact a lawyer to try to sue.
Right.
So
Yeah.
what kind of defense does that designer again have? They'd have to have an airtight something or other before they walk in the
without
door.
that contract.
Patenting the
Right.
the invention would be
That would
the
be
first
one way
thing,
to protect
or
it.
Or
copywriting,
the
whatever it is.
idea,
Yeah,
it's
the
not
idea.
been produced, because there's a difference, and you could probably explain this too, between the idea, the materials with which it's used, the process
Yeah.
for which it's being used, how it's being engineered. Some slight change of that makes null and void in many cases, that patent. So they're back to square one. And somebody who's very savvy about it is very likely to find a way to alter some portion of it so that they can claim it their own, if they're into
Perhaps.
that. If they're
Perhaps.
Perhaps.
But if the person who presented the idea or product to the company can show that we presented this, that they didn't, you'd have to also be able to prove they didn't have that in their pipeline already.
How would
Well,
the designer possibly know that?
I think
David?
that would be a defense. So the company might want to show that they had it in their pipeline, if they did have it in their pipeline. If they didn't, and actually, we had a case like this A fellow designed a tool that he wanted to sell to a company that makes a lot of tools. And he sent it to them, and he had the dates when he sent it to them, the dates when he met with them, the date when he first developed it, and all the contact he had with them. And their defense was, it was a great idea. We already had it in our pipeline, and here's when we first started developing it, and here's when we brought it out, and here's how long it takes us to roll out a product.
I think another good example of that is what's happening with Facebook litigation right now, because there are three, I guess they were partners, and two of them are not getting the credit.
They settled.
Yeah, no, but I heard they wanted to relitigate that again. They settled it.
I heard that they
finally
accepted. Yeah.
But there's an issue right there. I mean, who came up with the information?
Right. Well, whose idea was
it?
And what was the agreement? And if there was any, it's interesting.
And variation on a theme reopens this issue all over again.
Oh, yeah.
In many cases, the poor
Right.
designer. Well, isn't it always an issue of if you can't really pay to defend it, you may end up with the short end of the stick, which of course builds a good case for why we want to see a lawyer before we get delved too deeply into these things. So there are many of these leases, bills of sale, all available online, and some of them make a lot of sense that they could easily be lifted and used, and that they're open public domain and to be used. It also makes sense. There are times when we want to have a lawyer to review it. React to this. A $25 per page to review any small business contract. Evaluate that. It's $25 per page. You don't know what it is, but that's just an
online service?
online service. How do you feel about that? Is that something, would that be a buyer beware?
That is buyer beware.
I'd
You're
have
trying to
the-
save
yeah.
money, and you're actually getting service from someone that you never met.
Never met, you don't know what their qualifications are yet.
Are they
nor-
lawyers? Are they licensed
Well,
to practice in the law?
that's the issue.
Because now you have a
Is this the unauthorized practice of law?
Now you have an issue there. But, I mean, they're all over the internet.
Yes,
You can go to Staples and buy a contract. You can buy
Right.
a lease.
I would be more comfortable using one of those pay me and I'll tell you what's the matter with your car
Yeah.
when you give me the problem service, which I wouldn't even do, than getting legal advice from somebody who may or may not be a lawyer that I don't even know.
Well,
over
there's
the
an
internet.
issue similar to this because people are hiring debt negotiators or debt consolidators, and they're getting them off the internet. And these people are purporting to be attorneys, and they're not providing the service that they said they're going to provide. And now you've got litigation all over the country about that.
Well, if someone's positioning themselves to be lawyerly and able to provide that service and they're not, that's certainly one issue. And yet, because blogs and open-ended conversations are so common these days, it certainly makes sense that someone who wanted to have another set of eyes, or probably thousands, online could, because there are collaborative solutions by someone just
You
chirping
can
about whatever's going on.
absolutely get information, ideas, feedback, but don't consider it legal advice because it shouldn't be, and it isn't,
Even if it comes from the internet.
Yeah.
I mean, if we,
especially if it
Yeah,
comes from
yeah.
the internet.
But generally, we can say that those contracts, there are contracts available online that you can take a look at least gives you a
Sure.
good basis for start.
Absolutely.
Makes a more meaningful
As a
conversation.
start, not an end.
We thank you for tuning in. We hope that we've provided some helpful checklists and also some interesting thoughts for you to ponder as you are preparing your own contracts. And as we say always, we hope that you'll stay tuned, and I hope that you will continue to watch Legal Matters as we discuss various legal issues that affect you, your businesses, and your family life. Stay tuned. Our discussion of legal matters will continue.